of Markou financial conduct.
My lady, for the Mr. Rees Philip, the respondent, as electronic and hard copy. I anticipate using either.
Yeah, I think I'm hard copy bundles started you, but I don't mind.
Cool. This is my references bundle, but in the usual fashion. With the course, a we provide to the course.
Okay, so we're not running as such, but we've got a. That's very helpful, Mr. I assume that the court is what you've asked us.
Thank you.
Of course.
The FCA against the decision of the tribunal dated 27/2023 and 60 of the court.
Yeah.
That the reference arose in relation to the applicant, referred to as the applicant's conduct, regulated person within an entity FSE, and it was the FCA that the applicant placed FSE at risk as a vehicle for fighting crime, did not therefore protect the interests of consumers. The court noted that the applicant held two senior functions, SM, which is the direct function, and three chief functions. Those functions placed in the senior manager regime for which certain regulatory apply. The case, as it is a primary objective to prevent fraud in the financial markets, fraud is perceived to be particularly sector. Attack businesses in the financial markets, including organised crime, operate to the substantial of finance and of society. The FCA's summary concerned overarching allegations for lack of oversight by the applicant to self-employed mortgages who conduct day-to-day business, FSE, and as we'll see in due course, individuals operate in homes or individual services with resale minimal supervision. Second allegation, without fresh insurance, PI, contrary to the requirements. Third, overarching misleading evidence by the applicant and current reference. And FCA that the Upper Tribunal have concluded that act integrity of principle and thereby it or upheld the by the FCA, which was prohibition and 25,000 fine. But the Upper Tribunal, of course, and dismissed the financial penalty. My Lord's appeal, number of grounds, Justice Falk turned then immediately of appeal. Ground concerns jurisdiction and has to a large extent been by events, namely
Bluecrest decision.
In Bluecrest. Of course, in Bluecrest, the issue was absolutely fundamental. Had very substantial over 2 and has extensive judgment Bluecrest, which we say is correct, but is binding. Court, the relevant text is at paragraph 2. Authorities, but page 750. Is it helpful to give tab numbers, page numbers, or
yeah, it would be helpful to you to what extent this is really
well, we don't. Well, it's
disputed, then we don't.
I agree. Not disputed. There's an argument which is a bit of complaining that was the law. It's paragraph 2 of that's the test.
2.
Yeah, Boswell's judgment question. required by the concept of C. There's a sufficient relationship and the decision which to refer, and explains then is of some importance. And I'll be making remarks about Pendragon, but it's important to contextualise how the reference, it's a reference tribunal, fits to the regulation work. Broadly, it is a process that makes with a warning notice, follows decision notice, follows through to decisions before the regulating committee, reference. And then when it comes to it is a form of litigation. Speaking, our position was, therefore, one looks for pleadings, and it is as an adversarial dispute. It's slightly on from other. It's squarely adversarial, but the jurisdiction issue is whether there is a relationship between the matter of the right to fair. The critical question is the sufficient relationship, sufficiently related, which triggers the reference, or in the matter, or and significant matter of the process. So that's the test. Say that if that applied in the case, and the tribunal had asked in relation to the issues question, in particular leading point connected to the regulation for it, and the answer would be yes. It was evidence. It was strongly connected to the earlier FSE, and indeed the parties had approached on that basis in terms of that they had filed cross-examination. So it's a point in this appeal, in contrast to it is essentially accurate to say that the correct outcome that the tribunal jurisdiction in this case, all of the and ought to have so concluded. In any event, I want to determine issues, and because I did that, I need to more be able to, but I'm going to.
Okay. Right.
So to say about jurisdiction, and then get into the hard appeal, which are 3 to 5. With what we as preparatory on the approach. So Edward Stone Dragon, Edward's very long-standing as to the guide, no reasonable, properly instructed as to reach the conclusion. Statement of principle expressed in the and very regularly applied range of particular tax. Since then, there is a slight indeed, it is a weak tribunal, and therefore it is, we say, helpful to bear in mind the observations of Lord Con Pendragon, so 20 the authorities. A case, but reference to the 2007 Act 49 and 802.
9.
Reference to what is as the more approach, and then we'll move down to the from Lord Hoffman. In practice, this question is back upon whether as a matter one thinks this is a body with jurisdiction of law should be reviewed. Interesting, the academic question then, in fact, there is a principal threshold by policy that could, if efficient policy that would change it, would say that precisely the sort of that Lord Carnworth mind, because the Upper Tribunal, it as a pure tribunal, best expression of it is in Oliver's in Jabre, which is at paragraph 24.
Well, before Mr.
Yeah.
Brown, just look at this past dragon. It seems to me that it's purely and with issues of principle. All trying to put it to finding to me to be pairs with respect.
Well, obviously, facts and policy considerations hand in hand. They have a bearing on each other. I'll take the specific we have here. Here, the essentially concern behaviour of the dispute. So in order to decide what behaviour fringes regulatory make certain findings, which then to evaluate what that behaviour is, that conclusion about somebody's behaviour poorly, in fact, indeed part and partly impression stroke. And we, this area one is looking at standards where it's perhaps not useful to say fact finding. It is
the difficulty. I think it's my lady's page, paragraph 46, where that's what Mr. Fleming submitted. It wasn't being suggested, as I read it, that Edwards and Best present the right for the threshold where there was an error.
Yeah.
What he was saying, yes, it's Edwards and Best, whether there's an error. If there is an error to do about it, what he's really talking. He says here, doesn't it, such an error found. Court failed to take ended jurisdiction in 2007. That was context. See, it wasn't intended for, as it were, the Edwards and in a particular.
Yes, and this submission,
No, but I'm just.
Beds remains good law. House Lords will very long standing. The difference that we're trying to tease out that there has been a pure conceptual tax case where one the facts and then apply to those facts. And that's why there's no disputes about whether the facts we found are found because that outcome is a tax treatment. Here it's not as binary, procedures are slightly different.
See the argument. If on your as to, as for example, a professional insurance.
Yeah.
You say, well, on as found, concluded that there was a lack of intent. That, to the extent that issues, well, no, it's a of judgment tribunal. You say, well, this principle comes into
Yes. The
position is if the fact as found, then there was an error.
yes, that's right, my lord. So we
basically.
yes.
Hence, we don't need to guess it right.
Yeah. Essentially quibble. My lord puts it as found, particularly that really.
My point is really
It's the nub, isn't it?
the misleading evidence.
That is certainly very clear evidence, but we say the further grounds are all too, but right, we say with those factual conclusions, the correct application of the regime to those to being dismissed, in this case, provide. Reason why cycling dragon appear to have some one is talking about specific regulations such as this, as Sir Stephen described it in Jab briefly on that.
Tab 12.
Tab 12 for page 4. Is not an tribunal.
Which paragraph?
24. Tribunal is not a tribunal in neither some decisions of the statute, nor does it sit in appeals against decisions in the first instance. It's been created part of the regulatory process. It is there to consider the evidence and determine what is for the authority to take into the matter. That's then tribunal when it, for example, the tax security dispute as the upper tribunal is itself of the regulatory as opposed to necessarily a solely resolution tribunal. That means then it not only has facts, but it also has itself ensure that the purpose of FSMA, the Act, is. Now, that's asking a lot of, but it's a special tribunal, and that's what it do. And it's by of fairness. I'm certainly not suggesting it asks it to do there, though, of the regulation which Parliament has put in. And that places a slightly different position from structures, which isn't. That's the extent of the system. Okay. But we do see as this, that not based solely on and pure Edwards. Turning then to context, just a few points. Regulated activity PIR contrary to the regime at 135, 125.
Which paragraph?
330. Yeah. So note that one cannot regulate activity within that. There's 2 points to unpack slightly the scene around to appeal. The first time period. This concerns the new business.
Sorry.
New business. So what?
Yes.
Sort of quite a term that's used in particular, and it's important to that. There are 2 time periods where whether FSC without PI was realised. Those 2 periods are the 10th of July 2017 and the 10th of May 2017, the earlier date. Pleaded at the outset, how pleadings came to be set, was that July 2017 had no PI in place, and the applicant marking positive that his PI would not be renewed. Pleadings in the supplemental at page 116 in its paragraph 3. Things moved on after because the applicant served a statement And if I could ask this, please, the supplemental, it is page 117. Yes, tab 90.
Tab 96.
Like you said, at paragraph 9 of his witness reference, paragraph 8, he says, one of the biggest authorities in which this data dated 2nd of 2019, which case, that's a reference to the case. Led that I lied in the business under FS 9 May 2017, expressed that new work was to be under that date. I agreed to that, I set out 10th of May. Final sentence, the work was undertaken SE, the end of paragraph 8. It says unchanged, work was undertaken by F. And paragraph further and more important, despite referring to the fact that complete ongoing prior to 9 May 2019, the reality that there was no such taken, and then there's a reference to 14th of October, concerned about that. He says, final sentence, there was no period of time by FSE under insurance in place, by insurance 12th of May 2017.
So that's an assertion that new work nor after the 11th expiry.
Yeah, exactly. So there was a 10th of July statement and evidence. The FSA, we that sought to examine on that because it was perfectly clear from the evidence the tribunal found at the moment work new listing of those dates. Whether we would be able to rely on this date and subject of argument from the Upper Tribunal explains its reading paragraphs 174 as to why we rely on the 9th date. Go through that, but there's lots of reasoning where the tribunal is in the circuit going to allow the FCA to case. The applicant has not that. So just the actual conclusions.
9th of May date, 11th of May.
Well, the dates. 9th of May is used in the witness, and the 12th was used as a date when there's certainly no insurance. The actual date on which it expires is difficult to 9th, 10th, 11th, May of 2020.
Was it a weekend?
It's possible. Nothing turns on the precise date because the actual.
I want to remember it's my birthday. I remember whether it was
27. Yeah. It doesn't. Not only we also quite identify the precise issues are that in and after is being carried out. So the insurance has respondent advances on to about what he knows because it's expired, and he's not going until July. All of that. That's just what dates. It's introductory.
What happened is the insurance is expiring, and if there's a complication behind, but the request through the broker is covered.
Yeah, we cover through the brokers.
Cover pending resolution whether they're right for a few months. If you haven't got an answer to that question, insurance from the 9th or the or whatever.
Right. Out means there's the new business because again this is part of Mr. Markou's responsibility is to make a lot of the differences he between new and existing business, and we saw that partly paragraph 8 where it says no, and then paragraph 9 no to be regulatory perspective difference. They both PII. The reference, really the argument that was running, which sees in the, is recorded in 11 Roman 3, page 60.
This is
So now
put the statement.
pull the statement. So
Sorry.
yeah, 62 is where paragraph starts, and then 11, this paragraph records the case, and 11 records what without this. It says he was not aware of the renewal of NII on 10 July 2016, and he had a mortgage of take on new business 10th of May 2015. This was any failure to prevent FSE's from processing new business after was not immediately negligent or reckless circumstances, modest or there's 2 points there. It says not on renewal on that's a knowledge type. And then the second point, in terms of the steps that he took to the recklessness, he says, well, I took with the knowledge I instruct my mortgagors not to take on new business. May 2017. And that's the extent of this in terms of the steps he took in the circumstances they existed. He didn't advance a case that he'd given any instruction in any step to prevent the processing existing mortgages, which in fact it did in cases. And we understand in this of appeal, except reference to what they did in 25 of the skeleton arm, that the owner can do in due course. Now, very briefly then, equity and recklessness before we get into the conclusions. So the FCA was that Markou was reckless, that he allowed any business without PI. So he was the principal, he was the speaker, he had the conditions. His responsibility that FSE only carrying out with PII, and to do so be a very strong indicator of recklessness, and recklessness is a very strong indicator of lack of integrity. So it doesn't automatically follow. I've taken the course about what should do with the fact of things, but very difficult to see circumstances such as these would not. Pleading then integrity. There's also as to between reckless and integrity, and that is the judgment. I don't understand the dispute. Is paragraph 40, which is authority 21.9. Recklessness in relation with regulatory is an example of integrity, and conclude lacks integrity, reckless in regulatory obligation. That is so of a senior related function, director or executive, and the authority that pay an FCA, which is tab 8 authorities fund 59,600. That out really, I don't feel I need to go over. The problem is that some senior regulated is held in the general. So into a preferred, if one has the SNF3 function, for example, or related person. That's in the context of the regulation. In terms of is Canada Potter, subjective and components. So that is tab 3 to the court. If I can just read out the test, just take it as it's the head note. Recklessness, subjective element.
Page.
Yes, so tab 3. I was actually hoping to from the note at page 4, so head note. Recklessness is does and then if one down S.
Yeah.
So it's both the subject which require the defendant of a risk that a relevant existed, relevant result would occur, objective element to have been unreasonable known to the defendant that risk. Was aware of the relevant stance or the relevant, was it unreasonable to take the risk? Now, one has to understand what is meant by risk here. Say, potential error on the part of the tribunal, which we'll go through. But it's not the risk that, for example, damage to or actual risk with which is the risk that is running unregulated activity, the risk without insurance issue. So the question that the tribunal was circumstances where the defendant is aware because he's been told by is expired. There is the relevant circumstance, i.e. the business operating insurance, reasonable of or unreasonable to take this he took. Steps, as we've seen in the decision, it was instruction to the mortgage was not to take work. Those were the taken. As the tribunal considered to be important, it concludes no objective evidence of fraud or files. So it is, and it's all about in response to it.
Okay, can I just, the risk is trading without
Carrying activity with professional indemnity.
Yeah.
With respect to the tribunal's awareness, established from some date.
Yeah.
Reasonable mean in that context. You know your PIR, you say trading without PIR. So what are you looking for?
Well, this case is clear in those circumstances because as soon as you trade, thereby
You say that the only reason done would have been to shut up and make sure that no business
that aspect
transacted.
of mortgage business,
Mortgage business.
regulated. You can do commercial mortgage because that's not regulated. Residential mortgage business not carry on until he's got the insurance.
In one sense,
People who were running it not take on any of that, knew any of that business.
Well, it depends. So in the instructions, that then it's up to the tribe whether giving instructions, but we would say then see the instructions.
I follow. You say that such as were given were inadequate. Testing
Yeah.
would be reasonable. The reasonable thing to do is to show was just boundaries of that. Sure, if you give instructions that carry on the business until the insurance case and possibly the steps to ensure